Thanks for joining us here at the Thompson Center for the Chicago Bar Association's Candidate Forum, featuring the candidates running for the Illinois Supreme Court, or at least most of them. I am Paul Lisnek from WGN-TV. I am going to be serving as the moderator for this event. Brief introduction of me. Hopefully you are WGN-TV fans, where I cover politics and work as the political analyst on the station. And so we do, and every Sunday morning we have a show called WGN-TV Political Report. You will see a portion of this debate airing this Sunday on the show, so you want to tune in at 9 o'clock. It's also being filmed by CAN TV, so this will air in its entirety on CAN TV, so you can check it out there as well. I want to have a new fiction book called Assume Guilt. It's all about political corruption in Illinois. It's fiction. All right. That was a joke. It's always the line. Really? Fiction? All right. Before I begin the introduction of our candidates, who I will introduce in just a moment, I do want to invite Mariam Ahmed, who's the first vice president of the CBA. She's going to provide some welcoming remarks for everybody, so please welcome Ms. Ahmed.
Thank you, Mr. Lisnek. Good afternoon, everyone. My name is Mariam Ahmed, and I'm the first vice president of the Chicago Bar Association. On behalf of our president, Jessie Reyes, our board of managers, and our executive director, Terry Murphy, we want to welcome you and thank you for coming out today, particularly for those who are sitting in front of me in light of the weather. And we also would like to thank those who are following this event online, being live streamed via CAN TV. And we thank CAN TV for also covering this program. What a lot of you may not realize is that the Chicago Bar Association has been in the business of evaluating judges since 1874. The reason being is because the Chicago Bar Association believes that quality judges are necessary for a quality judiciary. And so we are very pleased to bring to the members of our voting public this forum to educate you about the 5 judicial candidates who are present, but the Supreme Court race in general, because of its importance not only to the state legal system, but to the residents of the state of Illinois. And so with that, I will turn the program back over to Paul. And again, thank you so much for joining us this afternoon.
Thank you. All right. Thank you. Once again, thank you all for coming out. There are some ground rules for the forum so that you know what they are, and so our candidates know what they are as well. I'm going to be asking you a series of questions, and you'll each have 1 minute to answer it. We do have timekeepers down here, so show them a sign, the one that says stop. Yeah. So we're going to give you a 30-second warning and a 15-second warning, and then the stop will come up. And I do ask that we respect that as we go, so we keep everything balanced between you. In addition, if somebody is called out by name or somebody mentions everything, we will give you 30 seconds to respond in rebuttal. So we will take care of that. We will be taking some questions from you guys, so this is a bit of audience participation. Though we won't ask you to stand them and ask them, what we will ask you to do, there are note cards. I think you have them in the back, or they'll get handed out. There will be people circulating around the room collecting them. So if you have questions that you want me to pose to these candidates, fill them out, and please, we'll send them to John, who's going to come around and get them. John, just stand up for a minute so they all see you. He will come around and catch his eye, and he will give them to me. So the questions, by the way, I should tell you, how many people in the room are not lawyers? Just out of curiosity. Yeah, so here's the good news, which is when we first began to do this debate and put the questions together, and I was going through a lot of them, I said, you know, this is great for people who are lawyers and judges, but unfortunately there are more non-lawyers who are going to vote than lawyers who are going to vote. And this is one of those elections where, look, let's be honest, people kind of skip the names on the ballot, and or they just pick somebody looking for a certain, a gender or nationality or whatever it may be, because they don't really understand or know what the issues are, because we get all caught up in the legality of everything. So the good news is that these questions are user-friendly. Which means even for those folks watching us on CAN TV, lots of non-lawyers tuning in, you'll be happy to know that you will follow these questions. You will understand them, and candidates, you will understand that these questions are ones that will be important to lawyers and non-lawyers alike, because obviously the system impacts everybody. So without further ado, let me introduce the candidates in alphabetical order, starting to my right. Justice Cynthia Cobbs is a justice currently serving on the Illinois Appellate Court in the 1st District. Prior to her service on the Appellate Court, Justice Cobbs served as a circuit court judge, the director of the Illinois courts, and as the senior judicial law clerk to retired Supreme Court Justice Charles Freeman. If elected, Justice Cobbs would become the first African-American woman to serve on the Illinois Supreme Court. Next to Justice Cobbs is Mr. Daniel Epstein. Daniel Epstein is a progressive who's campaigning to prevent wrongful convictions and corruption via systemic reform of the Illinois Supreme Court's rules of procedure, evidence, and ethics. Mr. Epstein won the prestigious Jenner Pro Bono Award for his legal service to vulnerable clients in cases in the Supreme Court of the United States and courts across the country. And in the process, he says he saw how money rather than merit can dictate outcomes, how some individuals can't take the first step towards justice because the courts are inaccessible to them. Mr. Epstein left his job at Jenner & Block to run for this position. And next to Mr. Epstein is Justice Nathaniel House, Jr. Justice House was elected as a judge of the Circuit Court of Cook County in 1998, initially assigned to the 1st Municipal District, where he served in numerous assignments, including traffic court, evictions, supplemental remedies, and civil jury trials. In 2001, Judge House was assigned to the County Division, where he presided over election cases, was the assignment judge for real estate tax cases. In 2009, the Illinois Supreme Court assigned Justice House to serve as a justice on the Illinois Appellate Court, where he continues to serve. Next, Justice Margaret Stanton Mcbride has devoted more than 42 years to public service as an appellate court justice for more than 20 years, a circuit court judge for 12 years, and an assistant state's attorney for over 10 years. Justice Mcbride has been found highly qualified for the Illinois Supreme Court by the Chicago Bar Association and the Illinois State Bar, the 2 largest bar associations in Illinois. Justice Jessie Reyes, raised in the Pilsen and Bridgeport neighborhoods. Justice Reyes was the first person in his family to graduate from college. He was the first Latino judge elected to the Illinois Appellate Court. Justice Reyes has been a judge for over 22 years. He's been found highly qualified by the Chicago Bar Association and other bar associations to serve on the Illinois Supreme Court. Throughout his journey, Justice Reyes has been a mentor to those with diverse backgrounds like his own and has encouraged young lawyers through his work as co-founder and president of the Diversity Scholarship Foundation. I should also point out at this time that the sixth candidate running in this race, Justice Sheldon Harris, declined the invitation to participate, and just earlier today, Justice Scott Neville informed us that he would be able to attend as well. So thank you to the candidates who are all here. With that said, we're going to go in order, give you all a chance to answer these questions, and I'll rotate who starts each time to keep that fair. And Justice Cobbs, we're going to start with you. Most lawyers and judges know who you are and are following the election, but the general public does not. So that the average voter does not skip this race on their ballot, tell us why the race for this office matters in the lives of our citizens, and what do they need to know about you specifically to make an informed judgment and vote in this case?
Thank you, Mr. Lisnek. I'm told I'm not supposed to move this mic.
Oh, okay.
So my time isn't being counted while I'm figuring that part out, right? Right. So
They say
in any
yes.
case, I'm Justice Cobbs, and I am the only African-American woman who is running for the Illinois Supreme Court. In the past, there have been 2 other African-American women who have sought to sit on that high court, and both of them have been unsuccessful. I'm the only candidate who is running who has done both aspects of the work of the Supreme Court. I've worked closely with Justice Freeman on the delivery of Supreme Court opinions for 7.5 years, and for 9.5 years, I served as the court's director, overseeing the entire court system. But more importantly than that, I've got the legal competence, but I also have the compassion and the empathy and the understanding of human nature. I've served as a clinical social worker for 10 years in my professional career. I bring both compassion, intelligence, competence, administrative ability to do the job of the Illinois Supreme Court, unlike any of my other opponents who serve here with me today. Important to me is access to justice, which is important to every litigant in the state of Illinois. As the former state court director, I understand how to managed all of those issues that confront the Illinois Supreme Court.
Thank you. Mr. Epstein, 1 minute to you. Tell us why this office matters in the lives of citizens and what they need to know about you.
So the Illinois Supreme Court doesn't just decide the biggest cases in the state, it writes all the rules for how our courts operate. Rules of procedure, rules of evidence, rules of ethics. And those rules that kind of linger in the background have a huge impact on our experience with those courts. Whether you can access them at all, whether once you get there they provide a fair hearing, whether you get the opportunity to tell your story before being pressured into deciding whether to take a plea or not, whether the judges that before whom you're going to appear get to determine their own conflicts or we have an independent body to do that. All of those things are decided by the Illinois Supreme Court because they write the rules. The fairest judge cannot achieve justice in an unfair system. It's critical that we create a fair system so that wise and good judges can achieve fairness, can find truth. That's what my campaign is about. Systemic reform to ensure that courts can find truth and we do provide fair forums.
Thank you. Justice House.
The most important job of the Illinois Supreme Court is to protect the civil rights of every individual. That's why it's so important. And I bring to the court two things. First of all, diligence and work. I want to hold the judges accountable. For the last 4 years, I've led the entire appellate court in terms of disposition of cases. The average judge had 12 to 14 cases on backlog. I've led the court for 4 years with 0, including the candidates, 5 of the candidates who are running against me for the Supreme Court. In addition, I believe that perspective is important for a Supreme Court justice. I was born in Murfreesboro, Tennessee, where I attended segregated schools and had to attend segregated movie theaters where we were forced to sit in the balcony. I believe that history and that background gives the judge a perspective. A perspective is important because many cases on the Supreme Court are decided by a judge's perspective. And I believe that I bring a unique perspective to the court which is needed in order to enrich the decisions which are made and to provide a viewpoint on the important issues.
Thank you. Justice Stanton McBride.
Good afternoon, everyone. I'm running for the Illinois Supreme Court because it's the most important court we have in Illinois. Unlike everyone else that's sitting here today, I have been a judge for 32 years. You've already heard that. I've sat in every major division of the court. I've been a presiding judge out in Rolling Meadows supervising other judges. But what's most important about me is that for 30 years, over 30 years, all of the major bar associations have always found me highly qualified because of my integrity, my fairness, and my ability to work hard. I'm running on my qualifications. I have heard thousands of people in court. I've heard thousands of cases, unlike most of the people sitting up here. I've also decided over 2,000 decisions in the Illinois Appellate Court. I am highly regarded by the whole state for the way I have conducted myself as a fair and impartial judge in this state, and I'm asking for all of your support in this election.
Thank you. Justice Reyes.
Yes, thank you. First of all, I want to thank the Chicago Bar Association and Mr. Lisnek for this opportunity. I'm the son of immigrants. I come from a blue-collar neighborhood. All I ever wanted was just a fair and just playing field. And that's the same thing that I provide in court with regards to whether I served as an associate judge, circuit court judge, or in the appellate court. It's provide and make sure that everybody gets a fair and just playing field. But I'm not only a judge on the bench and a public servant on the bench, but I'm a public servant off the bench. And I've had the opportunity to serve in a variety of different capacities. One of them was as president of the Illinois Judge Association. And I firsthand got the opportunity throughout the state to see some of the issues that we need to address in our justice system. And I also have a record that is without question of someone who comes in and solves problems. And that's what I intend to do as a member of the Illinois Supreme Court, is create, solve some of the problems that we're dealing with today. Thank you very much.
All right, next question, Mr. Epstein, we're going to start with you. The Illinois Supreme Court and the appellate courts are historically slow in rendering decisions on cases. None of you are responsible for that, just take you out of that. And as a result, people's lives are affected in dramatic ways. In criminal cases, this means people could be sitting in jail for extended periods of time before a ruling is heard. Do you believe it should be a priority to require the Illinois Supreme Court and the appellate courts to decide cases within a specific period of time? And if so, what is a realistic time frame, and how would you make it happen? Mr. Epstein, we'll start with you. 1 minute.
Yeah, I mean, so certainly there's an amount of time that would be far too long to wait because your rights can be lost merely by waiting. right? I mean, literally people can pass away waiting for an opportunity to appeal their decision. Businesses can shut down awaiting a decision. What that time is fairly difficult to determine, and I think that's it's not necessarily something that we would want to put a hard threshold on, but there is, I think it is critical to recognize that time is the enemy of the appellant, right? You can, in many cases. And a recognition of that is really important. So I don't know that there's a specific time. It's certainly something that I would want to look at. I know people who are in that situation where they're waiting for a chance to be heard, and they've been waiting for years. And it is traumatic on their life, and it's something that certainly I think we should pay more attention to. I don't know about a hard threshold, though.
All right, Justice House.
I've already addressed this problem as an appellate court justice. 2 years ago, I was chair of the appellate court executive committee, and I passed a rule which required any judge who had a case over 6 months old to explain why they had not completed the work and what needed to be done to help them complete the work. As a result of that rule being passed, the number of cases over 6 months old when I left as chair of the executive committee had dropped to nearly zero. As a Supreme Court justice, I have already shown I have the motivation to reduce the delay. And that's one of the big complaints I hear all the time is delay. But I've done it by personally getting cases out, by having a zero backlog for 4 years, and by passing the rule. And I've already done it. I've demonstrated that it can be done once you hold people accountable. And I think 6 months is long, but over 6 months was out of the question. There are people who are waiting, paying interest on judgments, and I've taken action on it already. So I'm in a position to do the best job on that.
Thank you. Justice Stanton McBride.
Actually, I do think we should have time limits, and as a matter of fact, when the issue came up in the appellate court about how long we should take to decide a case, I directed Justice House to the American Bar Association standards, which suggests that once a case is ready, it should be decided within 6 months. Now, I'm not certain what the ABA standards are for the Illinois Supreme Court, but I do think time is of the essence. I would also point out that this is something that can be done, but it's something that will have to be done with the majority of the court members. But I think that, we can get cases out faster. And as I say, we decided it was the appellate court that actually agreed upon a rule. It wasn't Justice House's rule. But the 6 months is the ABA standard, and I was the one that actually suggested we follow the ABA.
Justice House, you were called out by name, so you get 30 seconds rebuttal.
Yes, Justice Mcbride served as chair of the executive committee before me. I'm the one who got there and said, we have to put a stop to this 6 month rule. We had this delay in cases. I'm the one who took action.
All right, Justice Reyes.
Yes. So the Illinois Supreme Court, other than deciding cases, has administrative and supervisory capacity. For example, it oversees the appellate court, as was just mentioned. For example, with oral arguments, we have to have so many oral arguments within a time period during our quarter. The Supreme Court can also do that effectively with the chief judges around the state in terms of monitoring their courts and making a determination, why are certain cases taking a little bit longer than other type of cases, and hopefully, moving the cases along through our entire system. I think that's very important. I mean, some cases are more complex than others, and it's understandable why they might take a little bit longer to get through the system, but I think the Supreme Court can at least have a situation where they can monitor with the chief judges what's taking so long, and it could be easily done nowadays through technology, and everybody could Skype or get on whatever they want in terms of their phones or computers and communicate with each other.
Justice Cobbs.
So as the director of the Illinois courts, we already took into account with the Supreme Court some opportunities and measures that would be employed to assist the courts in improving their behavior or improving their conduct. As a matter of fact, as the director of the courts, I had suggested to the Supreme Court the implementation of performance and accountability strategies for the Illinois courts, and those strategies were adopted, one of which was to enhance mentoring programs in the circuit courts. Another program that we implemented and mandated with the Supreme Court was the performance and evaluation process, where judges are introspective and are mandated now as opposed to volunteering to be evaluated. I would put in place throughout the court system performance measures for every level of our court that would measure every aspect of a judge's work, and then that would provide us some metrics from which to then to decide how we might improve performance of judges throughout the state.
All right, thank you. Justice House, we're going to begin with you on this next question, which is important for lawyers who handle appeals, but non-lawyers will appreciate, maybe be surprised by what I'm about to put out here. There are a large number of civil cases that go through the court system, but aren't accepted by the Supreme Court. In fact, the Supreme Court took just 2 civil cases in a recent term. So let's move beyond quality over quantity and really address this issue. Do you agree that the court needs to hear more civil cases? And if so, what would you do specifically to increase the number of civil cases heard by the High Court? Justice House, 1 minute.
I believe that we should follow the suggestions of Supreme Court Rule 315 in deciding which cases should be heard by the court. However, when you only take 2 cases, I guess it does kind of let the public down. I would suggest that we do take more cases, but I don't think we need to have a fixed guideline about how many cases that we take. I think there are resources, we will have time to do other things, the Supreme Court, if they're not doing civil cases, and I think that time could be spent on rules and other issues. But I think we should look at quality, follow the dictates of the rules, and take cases where there are conflicts, take cases where there are great public interest, and take cases where their statutes have been declared unconstitutional.
All right, Justice Stanton McBride, once again, should the court hear more civil cases, and how would you increase that number?
I don't think that you can say simply that the court should take more civil cases. I think that the issue is really, is the court taking enough cases? I'm not there. I'm certainly of the feeling that we can always do more work, and so I think that that we could take, the Supreme Court could take more cases. But I don't think you can quantify that this case or that case should be taken. I have to agree with my colleagues that it depends on whether there's a conflict within the districts. It depends on whether there's a question of constitutionality. And also, I think that in cases where there's a dissent filed, those are cases that the court should always look at. There's obviously been a disagreement or feeling that one side feels one way and the dissent feels another. So I just think that you can't quantify. I think that the court has to look at, 1,200, 1,500 cases a year, and I think the review of those cases is very important, but I don't think you can quantify that the court needs to take more civil or more criminal cases.
Thank you. Justice Reyes?
So we have to follow the rules, but one of the problems that we have is unless it's a direct appeal to the Supreme Court, a lot of the cases come from the appellate court to the Supreme Court. And one of the problems that we're having at the circuit court level is that we don't have court reporters in the civil courtrooms. We don't have court reporters in the eviction courtrooms, housing courtrooms, the mortgage foreclosure courtrooms. Therefore, there's no record. And how is someone going to appeal? A lot of people don't understand it. They could file a bystander's report. I think that information needs to be provided to the public, and that could be provided very easily. And I think the public should be made aware of their rights in terms of how they could appeal civil cases. If the appellate court gets more civil cases on appeal, then just by osmosis, more cases are going to go up to the Supreme Court. But part of the problem is that we don't have a lot of people with knowledge and the experience and information in terms of how to appeal cases on the civil end to the appellate court.
All right, Justice Cobbs.
I absolutely do not believe that it is a quantifiable answer. I think that the court has to look at the importance of the case, whether or not it's resolving a conflict. I think one of the pieces of the Supreme Court's work that increasingly gets overlooked by attorneys and non-attorneys alike is the huge administrative burden of the Supreme Court. In talking with Justice Robert Thomas just a year or so ago, he expressed that 70% of the Supreme Court's work is administrative in nature. I can attest to that as having served as the administrative director. And so while we might think that the court's work is not balanced, I believe it is balanced in light of its mandate from the Constitution to oversee the court system. Should it take more cases? I believe that the characteristics or the qualities for determining whether to accept a case on appeal are fine. Should they be more diligent sometimes in looking at those cases? Yes, but it takes 4 votes. from the court to decide whether or not to grant a petition for leave to appeal. So on balance, I think the court is doing a wonderful job. Actually could take more cases, but administratively, I think they do well.
All right, Mr. Epstein.
Right, yeah, so a hard threshold, it would look bizarre, right? You would end up saying, well, we would have taken 2, but because the threshold says 3, we better take another case, and that's not really appropriate. But there are things that we can do, like changing Rule 23. Rule 23 may be burying circuit splits right now. They may exist, but it's hard to know because they're not precedential. And so it's very difficult to even know when there is a circuit split, if Rule 23 is ruling the day. But in addition, the issue of courts not providing transcripts is a serious one. Many of our courts do not guarantee a transcript, and also bystanders reports are not enough because judges sometimes don't sign the bystanders report, right? You're going to them saying, hey, I'm about to appeal you, please sign off on what I'm saying happened so that I can appeal you. And they just don't sign sometimes. So what we can do is wire up our courts with digital recorders, as we've started to do in Cook County in our eviction courts. I wrote an article about that in the Chicago Daily Law Bulletin some time ago, and I'm happy to say that recently we have wired up some of those, but we need to do it all across the state.
Okay. So this is a good time to say that if what you're hearing up here is sort of triggering questions in your mind, you're sort of thinking that kind of leads me to want to ask something, then you can fill out a card and bring them over to, or raise your hand, and John will see you, and he will come get the card. We will ask your questions a little later on, just to remind you of that. The next question will begin with Justice Stanton Mcbride. There are no set rules on an Illinois Supreme Court justice filling a vacancy on a lower court through an appointment. So as a result, there has been criticism on how judges are selected. As we all know, some are not necessarily qualified, and therefore the public could perceive individuals being appointed to the bench purely because of political pressure. What procedure would you use to appoint a judge to fill a vacancy in a lower court?
Like all of the justices, for the most part, that are currently on the Illinois Supreme Court, I would have a committee to review candidates for the vacancy. I think that the committee should consist of a number of Bar Association members. It should be members of the community. And I do think that after a screening process, an individual could be appointed. But I do think that as it is now, it's not really open and transparent enough. And so I would have a very open and transparent process.
Thank you. Justice Reyes.
So I've been on the record from the very beginning that the courtrooms belong to the people. Therefore, the people should decide who sits in their courtrooms. So if I get the opportunity to sit on the Supreme Court, I'm going to establish a committee made up of lay people, retired judges, and also lawyers. But then we're going to send out a public notice, particularly to all the ethnic bar association, the cultural bar associations, to make sure that everybody's aware that there's a vacancy that's occurring, and what vacancy it's in, what position it's in, and then accept public comment, and also put it out in the newspapers as well, and through the internet, to inform the public that there is a process that's going to be going on, there's going to be an appointment, and that they have an opportunity to comment whether negatively or positively about the potential candidates that are going to be submitted. Then I would have the candidates submit them credentials to the Chicago Bar Association Evaluation Committee, but also to the Alliance of Bar Associations as well. Because I think not only do we want qualifications, but we want to make sure that the people we put on the bench have character and integrity. And I see my time is up.
All right.
But then eventually I would put this nominee to the court and have the court, either vote up or down for it.
All right. Thank you, Justice. Justice Cobbs.
So currently, the court votes up and down on any nominee that is assigned for assignment or to fill a vacancy. It takes 4 votes, even though the Placidum might indicate that it's 7. It takes 4. I would have an open process as well, one that would be inclusive of a committee, laypersons. I would also probably enhance our notification to the public by the use of social media. Right now, the Supreme Court does use Twitter, but not for the purpose of necessarily announcing vacancies. If you look at the Supreme Court's website, some justices will use it to announce a vacancy. I would take better use of or enhanced use of social media to announce those vacancies. I would have a committee. I would certainly utilize the bar associations in much the same way that the justices are using them now. I would also invite public comment and then decide based on all of that information and in coordination or collaboration with my colleagues on the Supreme Court as to whether or not we should appoint, as opposed to simply circulating a vote memo, which is often what happens.
Thank you. Mr. Epstein.
Yeah, I would create a screening committee and put out open application and announce that widely. The screening committee, I think I want to emphasize the importance of finding folks who are representative of the community. One area that I think is underappreciated is experience outside of Illinois. There are jurisdictions outside of Illinois that have adopted ideas that we haven't here, and people who have practiced in those areas sometimes come into Illinois and are kind of shocked that we're not doing it that way. I think bringing folks who have experience in other systems into Illinois to help run our system is super valuable. We should do that. We should value that more highly. Also, I think it's really important that we not only allow open application process, but we actually actively recruit people. There are a lot of folks who would make outstanding judges, but don't think to apply, or think that or don't realize that they would be qualified to do it. And I think we need to go out and seek out those extraordinarily talented people and ask them to apply affirmatively.
And Justice House, once again, what procedures would you use to appoint a judge to fill a vacancy in a lower court?
I will, of course, appoint a committee to review the qualifications of candidates, but that's only the first step, because if you have a committee and you send candidates to that committee, and it's only the people that you know, then it's still just an insider's game. I will open up the judicial appointment process so that the public at large knows that there's a vacancy available, so that any qualified attorney in Cook County who wants to be considered to be a judge will fill out an application. No one will be appointed without completing that application and without being reviewed by the bar associations. And that's how I would open it up. I would give great weight to the bar association ratings and appoint a committee to review the best qualified candidates. But as I stated, it has to be opened up, because if you just have a committee, that you can feed anybody you pick to the committee. That's just the start. But you also have to open up the net to bring in more talent to the table.
All right, thank you all. Justice Reyes, we'll begin with you with this question. We hear a lot about the power and influence of money in campaigns at the national and local levels, and judicial campaigns, no exception. If elected, how would you ensure judicial independence in cases involving corporations or individuals who've donated to your campaign? Should recusal be mandatory, and if so, when?
I think recusal is very important. There's perception, and then there's also the actual conflict, and I'm always cognizant of that fact. I think you have to make sure that if there's a perception that there might be a conflict of interest, then you must recuse yourself. And also with regards to actual perceptions of conflict of interest, I think you need to recuse yourself. So I would definitely recuse myself from anybody who donated to my campaign with regards to whether they're a practitioner or it's an entity, a public entity, or a corporation. I think it's very important because, again, the Supreme Court is the pinnacle of the court system in our state, and so we want to make sure that people feel that their court is transparent. So therefore, I would definitely make sure that I recuse myself from any and all potential conflicts that might come up with regards to this campaign or any previous campaigns as well.
Justice Cobbs.
So currently, as a candidate for the Illinois Supreme Court, I have a tremendous firewall between me and any individual or any contributor to my campaign. Recusal is important, and it's a valuable tool exercised and enjoyed by judges. I believe that anyone who contributes or is known to have contributed to my campaign, I should recuse myself so as to avoid even the appearance of impropriety. It is critically important that the citizens that we serve have trust and confidence in the decisions that we make, and that they are confident that that decision is not based upon any individual or any contributor who might have made some contribution to our particular campaign. And so I would recuse myself to the extent that I became aware of anyone who contributed to my campaign, or if I were presented with a motion, I would consider that motion seriously as to determining whether or not I should not participate in a case.
All right, thank you. Mr. Epstein.
So there's this big problem, which is that both honest people and dishonest people will tell you that they are honest. right? Promises to recuse aren't good enough. Anecdotal assurances of fairness aren't good enough. We need structural assurances of fairness. So we need to create an independent body that determines conflicts of interest and recusals. Right now, we're relying on the honor system to stop judges from deciding cases for campaign donors. The honor system has a pretty poor track record in our state. We can do better. When I was working at my law firm, I couldn't even bring in new clients unless I went through a conflicts department. It's a good policy. Our judges should have to follow it too. And it's not something that's just a hypothetical. This is stuff that has happened in our state. Sometimes judges, even if they're trying to be honest, just don't have a good sense of what is an appearance of conflict. We need another layer, an independent layer, to tell us when there is a conflict or when there is the appearance of conflict. And in the meantime, I would pre-commit to create an independent body or an independent person to determine my own conflicts until we got that set up.
Thank you. Justice House.
I'm aware of the individuals who are chairing my campaign committee, and I will not hear cases that are before me involving those individuals. However, I do maintain a firewall, so to speak, because I don't pay attention exactly to my D2 statements. I don't read them. I do know who comes to my fundraisers, but I also give away free tickets so that there's some space there for people who I don't know necessarily who bought a ticket and who got a free ticket. I think that this is the system that we have is a bad system, but it's the best that we have. I would support public financing of judicial elections when our finances of the state permit, because I think that is really the best way. But right now, judges, in order to get the job, you have to be a politician. And I think we have to conduct ourselves in a way so that conflicts are not there.
Thank you. Justice Stanton Mcbride.
The code of conduct for all judges, and actually for candidates running for judge, is quite strict. And it requires that judges recuse themselves whenever there is an actual conflict or where there's an appearance of a conflict. I'm not going to have any trouble recusing myself in any case at any time. And if there's a conflict regarding a financial contribution, I will absolutely recuse myself. That's plain and simple. If there's a conflict in any way, a judge must automatically recuse him or herself. And if it appears that there's a conflict, the judge must also recuse him or herself. To say that the honor system has failed, well, I'm not sure what that means. But we have obligations, and all of us as judges and candidates must absolutely follow the Code of Judicial Conduct, and I will always do that, and I always have.
Mr. Epstein, you asked for 30 seconds.
Yeah, sure. So, I mean, 1999, a nationwide group of car owners sued State Farm Insurance, won $1 billion. That case went up to the Supreme Court. There was a vacancy and an election to fill that spot between Gordon Mogg and Lloyd Carmeier. The allegation was that State Farm funded almost all of Justice Carmeier's campaign. He wins the case, or he wins the race, joins the Supreme Court, and within months is tasked with deciding the case where State Farm is a party. The car owners petitioned the court, said, please don't let him decide this case. Our opponents just funded his campaign. And the court said, it's not up to us whether Justice Carmeier can decide the case. It's up to Justice Carmeier whether he can decide the case. And he said, I can decide the case. Cast the deciding vote in favor of State Farm to the tune of $500 million.
All right. Thanks for that clarification. You should join me on the Barbary podium when I lecture. We'll start again with Justice Cobbs this time around. And once again, you see this gentleman right over here. If you have questions, catch his eye. He will come around and pick your questions up from you. Justice Cobbs, there's something in court rules called Rule 23. In fact, Mr. Epstein mentioned this briefly before, which most folks outside of the legal profession know nothing about. So the rule itself says that the appellate court may issue decisions in cases that lawyers are prohibited from discussing in later cases. However, it's often said that bad decisions get buried in these unpublished Rule 23 orders because judges don't necessarily welcome full transparency on those decisions. Do you support or oppose the continued use of unpublished opinions under Rule 23, and why?
I think historically we have to think about Rule 23. So when I was a judicial law clerk in the appellate court, we published everything that a judge wrote. But back then, in the day, everything was published in hard copy in a book. We did have Westlaw and Lexis, but generally all of those opinions were published. And you pulled the book from the shelf. That was an issue with respect to economy. These days, and having served as a director, all of our appellate court offices and all of our state offices have access to Lexis and Westlaw, and many of our courtrooms and our court chambers don't have books. I would support, and it's been mentioned more than a few times to the Supreme Court, that we amend Rule 23 to allow many of those Rule 23 opinions or dispositions to be published as opinions. So I would support an amendment to Rule 23, which would broaden the number or the types of cases that could be filed as opinions. And I would also note this, that many times Rule 23s are supported by what is also already precedential law.
All right, thank you. Mr. Epstein, do you support or oppose the continued use of unpublished opinions?
So I think this is an example of one of the ways that our courts are stuck in the past. There's some lawyers in the room. I don't know if any of you have practiced in state court in California, but if so, it's frustrating because you can find precedent for anything. And so, I appreciate Rule 23 to the extent that it stops judges from putting out precedent that would not necessarily that they wouldn't necessarily be confident in. But at the same time, I think it's extraordinarily frustrating to lose on a Rule 23 order, and I think more importantly, it lowers the stakes that would lead to whether a justice or the court might grant a PLA, grant a petition for leave to appeal. If something is a Rule 23, it's not making precedent anyway, so why should we even worry about it? And it can also bury splits that are important to deal with. So I would support amending Rule 23 for those reasons.
Justice House.
I support the continued use of Rule 23 with one possible modification. I would support the use of Rule 23 as advisory rather than precedent. And the reason why is that many times Rule 23s result when there's uneven representation, and perhaps the case would have turned out the other way. For example, over half the cases in Illinois have self-represented litigants, and many times these litigants lose a case which, had they had a qualified attorney, they would have won. And you don't want to use a case like that where the case is lost because of poor representation to stand as precedent in important cases. So with that modification, I would say you can use it as advisory, but it shouldn't be used as precedent, and that would be my suggestion.
Thank you. Justice Stanton McBride.
Right now, I don't think a lot of people even understand what a Rule 23 decision is. It's not published, and basically the rule says that if you're not dealing with a case that's a first impression, like a brand new issue, or you're not modifying or changing existing law, then generally speaking, that decision will be a Rule 23. Now, I don't think courts use Rule 23 to bury decisions. The rule also allows for anyone to petition the court to publish the decision. But in any event, a couple of years ago, the Illinois Supreme Court considered whether or not the rule should be changed, and they decided not to change the rule. And for everyone else that's sitting here, right now, the Supreme Court Rules Committee, of which I'm a member, is considering this very issue, whether or not we should revise Rule 23. But I will say this, that everyone, any good lawyer that has any knowledge of the law, reads all of the decisions that are out there. I know I do. I look at Rule 23s all the time, so I always consider everything that's out there. And any great lawyer does that, and
All right,
so do
thank
the
you.
judges.
Justice Reyes.
Yes. So historically, Rule 23 was a cost-saving feature. It was a cost-saving rule. Opinions were in bound books, and it was becoming expensive. So the court decided to do away with some of the cases that were dealing with the same issue, and that's how we got Rule 23, basically. But now with the internet, all the cases, whether you're a 23 or an opinion or a summary order, they're all available on the court's website. So anybody, public or lawyer or whoever wants, they could go on the court website and view the case. I take a lot of effort in my cases, whether they're 23s or they're opinions. I want to make sure that the public can read them and understand them. So I take a great deal of effort to make sure that all of my cases I pay close attention to. Also, I've oraled Rule 23s. So in terms of 23s being a hidden type of case, it doesn't happen in my chamber because I don't do that. But with regards to your question, I would recommend that we reform and modify the rule, do away with it, because I don't think it really has any pertinent value anymore.
All right, thank you. Mr. Epstein, we'll start with you on this question. We all agree that diversity is significantly important in terms of representation in the courts and on the bench. In fact, the Sun-Times this morning had an extensive article about that issue, which Ms. Maude was quoted in. The results of this election could leave the High Court without any racial diversity. Should the court find a way to promote or guarantee diversity in future elections, and how do you do that?
Yeah, so diversity is important and representation is important, and it's important because our system is vulnerable to bias, is vulnerable to racism and bigotry. That's why it's important. And it's important because it impacts the customers of the court. It impacts the people who are on the other side of the bench. I'm proud that I'm running on an affirmatively anti-racist platform. I'm the only candidate with a platform. It's also an anti-racist platform. It's an anti-sexist platform. It's a platform designed to reduce bias. That includes in who gets to be on the bench, who gets to be on the bar, and who gets to be in the jury box. We don't talk about diversity of the jury box very much, but it's super important that we start taking on issues like racist jury selection. There are strategies to deal with that. And it all funnels back to those rules that we work on and that we need to work on more. That's what I've dedicated myself to do.
All right. Justice House, should the court find a way to promote or guarantee diversity in future elections? How do you do that?
I believe the court should promote diversity for two reasons. First of all, diversity is important from the viewpoint of making decisions in the court. When you have input with different perspectives on a legal question, you get a better decision. It's a more complete and rounded decision. You can get in a room with people who have just one viewpoint and get the same outcome, but you need someone with a diverse opinion to make it a very well-rounded decision. Secondly, the reason that the rules that our decisions in the court are respected is because we have this impression that our decisions are fair, and people come to court and they will accept a losing decision if they think they've been heard. However, when you come to court and you see that it's all the decision makers are from one culture, the people can be disappointed and disillusioned about how effective they are. So I believe that diversity should be one consideration. The most important way we can promote diversity is by appointment of judges, and that's what would be one consideration for me. Thank you.
Thank you. Justice Stanton McBride.
I also think that diversity is extremely important on every level of the court, and because of the reasons that everybody's already talked about. Different people bring different perspectives to the bench. And one of the ways, since we elect judges, one of the ways, though, that we can ensure diversity is through this appointment process, this extreme power that the Illinois Supreme Court judges have. And I would guarantee that diversity would be expanded and increased if I were elected to the Illinois Supreme Court. I don't think that, I think we can do more. I think there are lots of people that feel underrepresented in this state in the judiciary. And because of this important power that the Illinois Supreme Court has, that it is obligatory for the court, all seven members, to make certain that when these appointments to vacancies, which are only temporary, are filled, that diversity and qualifications are paramount in that consideration. And that's what I would do.
Thank you. Justice Reyes.
So I've always been a proponent, not just now when I'm running for office, but I've always been a proponent of diversity. When I was a young lawyer right out of law school and became involved in the Chicago Bar Association and Illinois State Bar Association, and I always pushed the issue of diversity. One of the things that I'm proud about with regards to my service with the Chicago Bar Association is that I was on the nominating committee that selected and nominated the first African-American male to become president of the Chicago Bar Association when Chester Blair submitted his credentials. One of the reasons why I started the Diversity Scholarship Foundation before it was popular to talk about diversity was because there was a lack of diversity in this profession. So with regards to my view on diversity, I think we do need diversity of perspective on the bench. I've been a judge for over 22 years. We've had 3 Latinos selected by the Supreme Court to the Circuit Court. We've had 1 Asian. We've had no Muslims, no South Asian individuals that have been named to the bench, and I think that's deplorable. We need to expand our horizons and make sure we employ more diversity with regards to selections.
Thank you, sir. Justice Cobbs.
So the issue continues to be implicit bias. And implicit bias exists not just in the court system, but everywhere. Just as a quick example, this morning I was told that the Chicago Tribune, in chronicling its endorsement, failed to even mention that I was the only African-American woman running in the race. How you could forget that? I don't know. How you would overlook it? I don't know. Implicit bias is real. But this is what I would suggest. I understand that the Supreme Court's appointment process is this. A nominating justice sends to the full court a nomination with a resume and a recommendation. Upon the vote of 4, there is an appointment. I would suggest that the Supreme Court sit as a body and receive every nomination to have full and fair discussion, taking into consideration gender and ethnicity. When I was the director of the courts, I recognized that we were not collecting that data. We did not know the makeup of our judiciary. Now, the administrative office of the courts collects from every new judge an application which identifies gender and ethnicity. I believe that the court should take stock of that information when making appointments.
All right, thank you. So we are about at the halfway point in the debate, and we are just a few questions away from coming to your questions. So this is a good time to remind you that if you have a question or you're going to write a question that you want us to ask, that this gentleman, John, will take a look at, this is a good time to raise your hand, get his attention. He'll come by and get it, because soon he will hand them to me. All right? But before we get there, I'll start the next question with Justice House. Court filings in Illinois are down 40 and 50%, between 40 and 50%. Data shows that many individuals are either filing matters pro se, meaning representing themselves, or not filing actions at all because they're too expensive, or they're inconvenient, or they don't trust the system, or maybe they don't know enough. If our citizens are not using the court, one could argue that's a major problem for the court system. Is the justice system broken in this way, and what can be done to make the justice system more accessible for everybody?
The Administrative Office of the Illinois Court has taken some data, and they found that in most counties, in over half the civil cases, there's at least one party that's self-represented. And that's the issue that we're really looking at, because it's so expensive to get an attorney. But we can make the system better and work better for self-represented litigants by making forms that are in multiple languages, making them so they're easier to read, so they're not necessarily in legalese, and having court facilitators available to self-represented litigants to direct them to different places. We can also try to innovative programs to allow them to get help from volunteer attorneys. For example, if you can allow an attorney to represent a party or give advice to a self-represented party in the beginning when they initially draft their complaints, so that at a critical stage they're getting off on the right foot. But I think that's the way we can help to improve.
Justice Stanton McBride.
Access to justice is obviously very important, and the Supreme Court of Illinois has instituted a commission in 2012. They're doing a lot of work in making sure that access to justice is available to many citizens. Actually, we already have complaint forms and appeal forms that have been translated into 6 languages. There's efforts to make accessibility to the various courtrooms with recordings. So I think that efforts are being made, but we can always do more. And I think that access to justice is probably the most important issue that's facing the court system right now, and I think that efforts are being made, but there can be more that is done. And I would encourage also, as Justice House has suggested, more pro bono efforts, and also the improvement in legal aid, and that's kind of how we're going to get this thing moving faster than it is. But it's absolutely critical that people feel that they can access the justice system so that they don't think it's designed for the rich and not for those that can't afford legal services.
Justice Reyes, once again, how do you design the system to make it more accessible?
Sure. So it has to be more user-friendly, and I think the way you start out by doing that is to provide information to the public beforehand. A lot of times they get to the courthouse, they find out that they don't have the documents that they need, or they don't understand the forms that they need to fill out, and then they keep going back and forth. So I think we have to provide public access information to the public to inform them how they can use their courtrooms, their courthouses. For example, when I was in traffic court and we had a situation with DUIs, we incorporated the help of various TV stations to get the information out to the public with regards to what their rights were, with regards to coming to court, and what the consequences were of violating the law. So I think that, we could do that in terms of using public access television, programs like CAN TV and things of that nature to get the information out to the public, to make them aware. If you're going to housing court, this is what you need to bring. If you're going to eviction court, this is what you need to bring. And then also do it in multiple languages and have the forms available in multiple languages. The courtrooms, again, like I said, belongs to the people, and we got to make sure that they know how to use their courtrooms.
Thank you, sir. Justice Cobbs.
So the court, I think, is engaged in quite a bit of work with respect to access to justice. I would remark that some of the downturn in the number of cases filed might have some relationship to the number of alternative dispute resolution programs that operate in our state, ADR, JAMS, and the like. Access to justice continues to be a real live problem. We do have forms that have been created in various languages and forms that guide our litigants who are self-represented. I would propose that under Rule 711, which is administered by the Director of the Illinois Courts, that a percentage of the time devoted by law students under the supervision of licensed attorneys be at the help desk in our various levels of courts, so that when self-represented litigants approach the courts, that they get the legal assistance that they need, again, under the supervision of a licensed attorney, such they know what to expect, how to conduct themselves, and perhaps even how to plead a better case or a complaint once they get into court.
And Mr. Epstein.
A few years ago, I was talking to a group of people who were all laid off from a factory here in Cook County, and they were all undocumented, and I asked them, how many of you have experienced wage theft? And every single one raised their hand. And ask, how many of you have sued the people who stole your wages? And every single hand went down. They won't set foot in our civil courts because they're afraid that ICE is there. They don't have the privilege to be able to physically appear in court, and they're not alone. People with caretaker responsibilities, people with jobs, people with mobility challenges. Getting to court, just physically getting to court, is very difficult. But the good news is we have fancy new technology that can help us do this. It's called cell phones. It's called computers with web cameras. Other jurisdictions are already enabling remote appearances. It actually earns revenue for the system. We can do that here in Illinois as well. It makes our courts more accessible, more fair, and it makes our rights real. We should do it.
All right, thank you. Justice Stanton Mcbride, we'll begin with you on this question. We require that attorneys take continuing legal education courses, of course, but we don't make them maintain professional liability insurance. And just in case the non-lawyers are here, you care about that because that would impact you if you were to file a malpractice claim against a lawyer. Would you support a requirement that all practicing lawyers in Illinois carry professional liability insurance, and should all lawyers be required to disclose to their clients if they do not carry professional liability insurance?
I would support a proposal to require that attorneys carry malpractice. And I would also support the notion that if you don't carry it, it should be told to a client automatically.
Thank you. Justice Reyes?
Yes, I agree as well. I mean, I think it's a protection for both the public and for counsels who are practicing law. So I definitely would propose a rule along those lines in terms of making sure that everybody has insurance, and then also that makes sure that that becomes knowledgeable, that knowledge is provided to the clients.
All right, Justice Cobbs.
Absolutely, and I do believe that every year when you register as an attorney, you do have to complete certain fields to make certain disclosures with respect to insurance coverages. So I would support a rule amendment that would create or require, mandate that you disclose the availability or that you are covered or not.
Mr. Epstein?
Yes and yes. So not only is it a good practice to prevent unremediable injuries from malpractice, but actually holding insurance can improve behavior that prevents a problem from happening in the first place. The influence of rates on behavior is something that's worked in auto, in environmental issues. Insurance can have a positive impact on behavior and make sure that some of the problems we see from attorneys who may be a little bit more fast and loose with their practice come into line and behave appropriately. For those who don't know, by the way, you can find out whether your attorney has malpractice insurance. I think you can do it at the IARDC website, so you can check it out there, and it's important that you do.
Justice House?
Yes, I think a mandatory disclosure is important to disclose to a client that there's no malpractice insurance. I also believe that it is a good idea to require insurance, but you have to work out certain problems. What are you going to do about the new lawyer who comes out of law school with a $200,000 debt and trying to set up a law practice? We have to address all those issues, but it is a good idea in principle so that individuals who suffer at the hands of a lawyer who makes a mistake can be compensated. Now, there is already some relief where there's a lawyer where there is misconduct involved or gross negligence with the ARDC relief, but for ordinary case, there's no relief. So I think that is a good idea, but you have to make allowances for those new people who come into the legal practice who don't have the financial means to afford insurance.
All right, thank you. Justice Reyes, we'll begin with you on this question. Data, statistics, and cost savings point in favor of a single filing system controlled by the Supreme Court. This means that the Illinois Supreme Court would be the sole collector of data, and all courts would report their findings to the Illinois Supreme Court. If you agree, how would you support a unified e-filing system for all of Illinois, and what specific changes would you make to move the initiative forward?
Well, first of all, I think e-filing the system is great, but we also have to be cognizant there's a segment of our population where it wouldn't benefit them. They don't have access to computers. They don't know how to utilize computers. So I think before we went to unified e-filing system, we have to make sure that our courtrooms and our courthouses are, again, user-friendly for all members of the public, not just certain individuals who can utilize a computer and are knowledgeable how to use a computer, but we also have to make sure that those individuals who are not able to use a computer, that there's an alternative means by which they could provide their filings, they could file their pleadings, their responses, and I think that's also necessary before we even go to a unified e-filing system.
Right, Justice Cobbs.
So the statewide system that you are proposing is analogous to the system that exists in the federal court system, PACER. For many, many years, the Supreme Court has grappled with the notion of how to have a unified e-filing system. The problem has been that in each of our several counties and circuits throughout the state, every circuit clerk who is elected in every court or every circuit is permitted to design or to contract for his or own system. So what we would need to do is find the dollars in the first place to unify all of the court management systems or computer systems throughout the state. That requires partnering with the legislature to get that done. It's not impossible to do, but it would be costly, and it requires some collaboration with our legislature in order to have the budgetary resources in order to modify that system statewide. We've been engaged in e-filing throughout the state of Illinois for many, many years, starting back as early as 2004, starting early with the DuPage County's e-filing system. But there is more to be done, but we would need money to get it done.
Thank you. Mr. Epstein.
Yeah, so the PACER is outstanding. For those of us who practice in federal court, it's a great tool. And if we can mirror that, I think that would be an incredible advancement. I think there are other states that have gone through this process, and I'd like to see how they did it. It very well may require lobbying the legislature for extra resources. If so, then that's something that we need to do, because this idea that this thing that we're experiencing isn't just a small hurdle. It's a big hurdle for people accessing their rights, and I think we need to address it in that way. There are outside vendors who we can use as well, who may be able to help us. Some of the remote appearance stuff links up with filing, back-end filing systems. So it's going to take an aggressive approach, but it's worthy of an aggressive approach. It is that important.
Justice House.
I think it's a terrific idea to have the single filing system. It enables everyone to have access to the courts, better access to the courts. Individuals who don't have computer access can probably go to the public library. It's part of bringing our court system into this 21st century. I recall when I first started practicing in 1976, there were individuals whose job it was to go around to the various law offices around 2:30 or 3 in the afternoon and pick up filings to take to the circuit court to file. I think that the filing system, electronic filing system, is terrific. It is the best way to go, and it's bringing our system into the modern age.
Justice Stanton McBride.
I agree that we should move forward with the uniform filing system, and it has been referenced that this system that you've described is pretty much like the federal system, the PACER system, which most lawyers that practice in federal court thinks works quite well. But as Justice Cobbs has pointed out, and others, this would require funds, and anything that we do has to come through the funding process. But certainly we want to have a uniform system, and I think the Illinois Supreme Court is actually already working on this. They're trying to make certain that everything we do is unified throughout the counties. And in terms of those that would not have access to a computer, we already have exemptions with e-filing now for those that don't have access to a computer, and of course we could always expand that, but I agree that it's a great idea, and hopefully we can get there, and we should get there.
All right, thank you. So we come to the audience participation part of our program, where John has given me questions that you have posed. If you had one, you went, oh no, I didn't give it to him, give it to him. I'll still take a couple if you've got them. I will use as many as I can up here. With one apologies to somebody who wrote on both sides. I'm doing my best to decipher this. I'm having trouble reading it, so if this was you, I apologize. I'm going to try. Justice Cobbs, we'll start with you. At this juncture, you are all familiar with your opponent's qualifications. What one credential makes you the most uniquely qualified candidate for this Supreme Court vacancy?
Someone's been reading my tagline. I'm uniquely qualified because the work of the Supreme Court has been outlined by many of us here, is both to dispose of cases and to administer the judicial branch, the entire court system. I'm the only candidate who is running who has done both aspects of that work. I am currently an appellate court judge deciding cases. I was a Supreme Court judicial law clerk, having worked on Supreme Court opinions, reviewing motions that came before the Supreme Court, reviewing petitions for leave to appeal, as well as petitions for rehearing. For 7.5 years, that was my work. I also served as the director of the Illinois Supreme Court, of the court system. Appointed by the court in 2002, I did that job for 9.5 years. No other candidate can claim those qualifications or those credentials. Having done the work of the Supreme Court and having continued to serve as a trial judge and as an appellate court judge, I am uniquely qualified to serve as a justice on the Illinois Supreme Court.
Mr. Epstein, why are you uniquely qualified?
A platform. I'm the only one who's laid out what I want to do and how I want to change our system. The Illinois Supreme Court, like I said, doesn't just decide cases, it writes rules. It is a policy-making body. So it's critical that we look at what policies folks want to change. I'm out here saying we need to end cash bail. The Illinois Supreme Court has a role in doing that. We need to address the fact that our courts right now are entitled to extra funds if they convict. We need to address the fact that right now we're relying on the honor system to stop judges from deciding cases for campaign donors. We need to change our expert admission standard from the Frye test to the Daubert test. We need to expand discovery in criminal cases to allow depositions. We need to help our restorative justice courts flourish. We need to make it so that you can appear in court online. I've laid out everything that I want to do. If you go to epsteinforsupremecourt.com, you can go and see this platform. You don't have to wonder. We've laid it out, and we're the only ones who have.
Justice House, why are you uniquely qualified?
I have 43 years' experience as a lawyer and a judge. I have spent 22 years practicing law and 21 years as a judge. The bar associations have rated me either highly qualified, or highly recommended, or at least minimally qualified. I got the highest rating for most of them. And I have a unique perspective, and that is I'm a person who went to segregated schools. I'm a person who had to sit in the balcony in a segregated movie theater. I understand what it means to be an underdog and how it feels to be an underdog. And I will bring that perspective to the court and bring it to the decisions that are made while I'm there. So I believe that those qualifications are unique. I understand there's segregated schools in the city of Chicago, but none are legally segregated like I had to go through. And that's a put down. It's a put down to make you feel second class. And I know that feeling, and I will bring that sensitivity to the court.
Justice Stanton Mcbride, what makes you uniquely qualified?
Independence is the hallmark of the branch of government that we call the judicial branch. Apart from all of my qualifications, the depth and breadth and years and experience that I have, and all of the highly qualifieds that I've received for over 30 years, what makes me uniquely qualified is that I am an independent judge. I came here, I arrived here, I'm on the appellate court, I was elected to the circuit court because I was elected by the people, having been found highly qualified by every single major bar association for the circuit court and the appellate court. I'm running again on my qualifications for the Illinois Supreme Court. You've heard that old expression, it's not what you know, it's who you know. I am what you know. I was never appointed to any position as judge except for an associate judgeship. I have run for every election on my qualification, my integrity, and my independence.
All right, thank you. Justice Reyes, why are you uniquely qualified?
Well, I came from an economically disadvantaged, marginalized community, and I had to find a way to get out of that community to get where I am at today. And so I bring a unique perspective in terms of being a problem solver. I mentioned earlier about the disproportionate number of people that were coming into traffic court that were being charged with DUIs. We addressed that issue. When I was in mortgage foreclosures, I established a process where we were able to give people who were suffering through foreclosure process some dignity and being able to maybe save their houses. We wanted to make sure that they got justice. With the lack of diversity in our profession, I established the Diversity Scholarship Foundation and have helped out young people and lawyers and judges to proceed and get into this profession that otherwise would not have had the opportunity. And lastly, you know, I'm the only one that's talking about mental health here. We have a large community with regards to who's sitting in our Cook County jails that have never even been in front of a judge because they have mental health issues. You know, I'm a trained lab intervener, and that's part of the reason why I think we need to address this mental health issue that's affecting our communities.
Thank you, sir. Mr. Epstein, we'll start with you. This is kind of an open-ended question, I think, from one of our audience members. What are your thoughts on official misconduct and immunity?
Yeah. Obviously tragic, right? It's a very difficult one. I mean, you want your public officials in some ways to be able to conduct their jobs without fear of entering the close. When you enter the close, you take on the risk, but in some cases we ask people to enter dangerous closes, and that can make things difficult for their job. But I think right now we're at a time where we're just seeing so much of it, and we're seeing it in a much more intimate way because of cameras and because of advances in reporting, and that I think we need to have an open conversation about whether it needs to be as extensive as it is right now, because qualified immunity can be extraordinarily extensive in ways that protect serial misconduct that happens over and over and over again. And I certainly think it's a conversation worth opening.
All right, Justice House, your thoughts on official misconduct and immunity?
I think that individuals who are accused of official misconduct and are prosecuted, whether or not they get immunity is really a prosecutorial decision. And that's usually made, as I understand it, when the person who's being prosecuted has information on other individuals who may be brought into justice system, people who would not otherwise be able to be brought in. And that's a prosecution decision, and that's where I would leave it.
Justice Stanton McBride?
Official misconduct is a crime, and whether or not someone is given immunity really depends on the facts of an individual case. Under Rule 67, we can't really, talk about how we would rule on a certain case. So all I would say is that this is a crime, and whether or not someone is given immunity will depend on the facts of the case. And occasionally, the courts may be called upon to resolve something or some issue in a case of official misconduct. But other than that, I really don't see what I can hypothesize about under Rule 67.
Justice Reyes, immunity and misconduct.
Well, I agree with regard to Rule 67, but I think it's a case-by-case basis. And the only thing that I would point out is that, as a result of some of the testimony that came through in Operation Greylord, our system, although it was a black mark, a dark day for our profession, but yet at the same time, it was a benefit. So I think it's a case-by-case basis in terms of whether or not immunity should be granted.
Justice Cobbs.
So official misconduct, to the extent that someone is found guilty of having engaged in that, certainly they should be prosecuted. Whether or not immunity is granted will depend on the facts of the case. In the context of judges, our conduct is governed by the Code of Judicial Conduct. To the extent there is a violation of the code, the Judicial Inquiry Board is given authority under the Constitution to investigate any complaints. And should that complaint be valid, then it is the Illinois Courts Commission that will determine whether or not a judge will be sanctioned for that misconduct. So I know I've taken it a little off from where you wanted, but I wanted to bring it back in the context of judges, since that's where we will sit once I am elected as the Supreme Court Justice.
All right, thank you. Justice House, I'm going to start with you on this question. Mr. Epstein, I intentionally have you going last on this question. You'll understand as you hear it. So, Justices, do you have any undecided cases over 6 months old? And if so, how many?
I have 0, because, and I actually put a rule in which was adopted by the court. I proposed a rule adopted by the executive committee which addressed cases which were over 6 months old. So I don't have any.
Justice Stanton McBride.
I don't have any.
I do not have any, and I've never had any.
Justice Cobbs.
I think I have one, but I think there's a bankruptcy issue that's pending.
All right. So you see, Mr. Epstein, although you don't have cases pending, but I do want to let you answer that question.
I have 0 cases pending, and I have never had any cases pending. My record is perfect on that.
All right. Justice Stanton McBride, what do you think of the challenges and benefits of the court sitting as a body together for weeks at a time?
The benefits and the challenges?
The benefits and challenges of this is when I'm having difficulty reading, but I'm doing my best, of the court sitting together for weeks at a time.
Well, I think the benefit is that it brings collegiality to the group. They have to discuss the cases. I think the best way to be able to do that is to be together with the members of the court. It's similar to what we do on the appellate court. We sit for cases, then we have a conference, we discuss the cases, and that's how we reach a decision. As far as the challenges, not having been there or done that, I don't know that there be any particular challenges that would be difficult to manage.
All right,
So-
Justice Reyes.
I think there's a lot of benefits. You get to know your colleagues. Also, in terms of making decisions, judges don't just do them by themselves on the Supreme Court. So you get to collaborate with your colleagues and kind of get to understand them, their way of thinking, their philosophy. So I think there's a lot of benefits to being together for that period of time. In terms of challenges, I agree with Justice McBride not having been there yet. I will let you know once I get there what the challenges are, but at this point in time, I can't perceive any challenges.
Justice Cobbs.
One of the hallmarks of the Illinois Supreme Court is its ability to be collegial. So during the court's term, the entire court, all 7 justices are in Springfield, where they reside on the 3rd floor of the Supreme Court building. They take their meals together on that 3rd floor. They have living quarters on that 3rd floor. And during the times that they are deciding cases or administrative matters, they meet in the conference room downstairs. That collegiality and that living together in that same space accords the court the opportunity to dialogue and have discourse and conversation about the many case and administrative matters that confront the court. And so I don't really see a downside of it. There is some talk or some suggestion that if you write a number of dissents that somehow sets you apart. I think dissents are good, but I think that the better quality is the ability to build consensus without compromising your judicial philosophy. And I think the measure of collegiality and living together as a court is what kind of enhances that ability on the Supreme Court.
Mr. Epstein.
Yeah, I think there's the idea in part is that there's a benefit to a kind of a form of isolation, a group isolation where the justices can step away from things and interact with each other on issues that are solely before them. And I think there's something good about that. I also think that sometimes reservedness of judges is generally a virtue, but it's also super important that, especially with respect to the policy-making role of the court, that justices be in the community. That isolation can sometimes be too much. And as I travel around the county and talk to folks, I can tell you they don't feel like they know who their judges are and what they care about. And so I think there's a role or something to be said for getting into the community a little bit more. I don't think that necessarily detracts from the fact that there's something positive about the fact that the judges literally live above the courtroom itself. And I guess the detractor there is that, if one of the justices, microwaves fish or something, then everyone has to smell it.
Justice House.
We know we have 5 districts and judges from all 4 corners of the state, and theoretically, they could meet by Skype or sometime way electronically. But I do think being physically together gives a different focus, a closer focus on the work at hand. And it gives a more collegiality. You tend to be more polite to people you're right in front of as opposed to those you're online with or communicating with electronically. So I think there's a benefit to building consensus, working together, and giving motivation to get the job done by having everyone meet in one place.
All right, just a couple of questions left that we're going to ask, and so and the last one I think is sort of fun, but this is not that. We'll start with you, Justice Reyes. Understanding that there are limitations placed on you by the Code of Judicial Conduct, how can judges and lawyers educate the public about the judicial process or otherwise raise the profile of judicial elections?
Oh, I could talk for hours on that one.
We'll give you a minute.
So one of the things that we've done through the Diversity Scholarship Foundation that I established years ago is we put on CLE programs and we highlight people from different cultures, ethnicities, so on and so forth to speak on topics, because I think that's important because they bring up a certain perspective. And we also talk about how to become a judge. But I think in these programs, especially when they're televised on like CAN TV or other television programs, I think it helps the public get a better understanding what judges are, and then also with regards to what practitioners do on a daily basis. Something else that I do on a regular basis, I invite students to come to the appellate court. I did it in the circuit court and I do it in the appellate court. I ask them to sit and watch oral arguments and then we talk afterwards, because I think the young people need to understand about our justice system, how it works, and get an opportunity to see it close up. So I think those are some of the ways that maybe you can possibly enhance the image of the judiciary, because I know a lot of times we get a bad rap, but I think in terms of having face-to-face communication with young people and adults is a good way of enhancing the image.
Justice Cobbs.
So I think the more we are able to engage with the public and to provide them with information about the three branches of government, and particularly the third branch, the judiciary, the better we're better served. So there are a few things that I think some are already in the works and some that could be done. When I was the chairperson of the Illinois Judicial Council, I created a program called The Conversation with the Judges. I had several judges who would go out to community organizations and not in robes, but to sit and engage in conversation with members of the community about the court system, about processes in the court. One other thing that I think that the Supreme Court could do a better job is they're already on Twitter. We did that in 2004. We have a Speakers Bureau through the Supreme Court. We could be more actively engaged in getting our Speakers Bureau well known and out there. But we can make better use of social media and use of the court's website to drive individuals to that site and to utilize social media, which could put out daily better information or more information about the court system and elections and processes about becoming a judge and how the branch functions.
Mr. Epstein.
Yeah, so you mentioned Rule 67, which says that you can't make comments that would commit you or appear to commit you to how you would decide cases, controversies, or issues within cases that are likely to come before the court. That really, in other words, don't talk about how you decide cases, right? That's all within the adjudicative function. But the court has a second bucket of responsibility, non-adjudicative, rulemaking, administrative authority, supervisory authority, all this policy-making power and activity that we can talk about all day. And we should. We should be talking about how the court does operate and how it should operate. And that's what I've been doing on this campaign. It's been a political campaign, but it's also been an educational campaign. And I think it's really important that we clarify, one, we can talk about that stuff. And there are court cases that are on point here. There's a Supreme Court case called White, a Seventh Circuit case called Buckley that talks about our ability to announce views for the purpose of improving the law. We can do that. And we should do that because it's important that people understand how our courts work so that we can improve it. People should be able to invest and improve their justice system by understanding what it is and voting for it.
Justice House.
I think forums like the one you're having today is a valuable tool in informing the public about what's going on with the judicial system. I think more people could have taken advantage of today, but I think that's one important way. When I go around campaigning, a lot of people don't know, what does an appellate court judge do? And they don't understand, so I enjoy explaining how we do the steps that we take in deciding cases and exactly the difference between the appellate court, the circuit court, and the Supreme Court. So I think by going out, having forums and going out and making yourself available to visit schools, churches, and explaining our function, I think that's one important way.
Justice Stanton McBride.
I think that outreach is very important. Currently, the Illinois Supreme Court, through the circuit court level, has a speakers bureau. Judges routinely go out and speak to audiences, not lawyers. The Illinois Judges Association has numerous programs that are in the making that have already been made about well, a lot of judges go out to high schools and talk to students about the dangers of things with the internet and everything else like that. I for years, participated, actually created a program of mock jury trials in a grammar school in the suburbs of Chicago, and I presented that for 5 years with people in 6th, 7th, and 8th grade so that they could understand about the jury system. Many of us on the appellate court have actually brought oral arguments to the law schools. Some of the other judges have brought them to junior colleges. I don't think there's any question judges need to get out there more. The other thing that's really important is that judges can speak to the legislature on subjects that they think the legislature should address. And I think right now there's a number of issues that judges can participate in terms of speaking to the legislature about the issues we have involving crime and the prison population. The United States has more people in jail, more African Americans in jail than any other country in the world. So there are things that we can do, and we're doing them, and we should do more of them.
All right, this is going to be the final question. As I said, it's going to sound a little fun to you, but I actually mean it as a serious question. So take a moment and think about it. And I'm actually going to give you, if you want to use it, we'll give you up to 1.5 minutes to answer this question. Our timekeepers are probably going to, you can handle that, right? Okay. So think about this. There's a lot of legal television shows out there, series, a lot out there that talk about the law and the legal process these days. People love them. People watch them all the time. If you were asked to create a TV series in Chicago based on Cook County's legal system, what would you call it, and what would it look like? Keep in mind, this will essentially also be your closing statement. So I'm going to give each of you 1.5 minutes to talk about the name of the show that Dick Wolf would ask you to create and what it would look like to represent the system. And we're back to the beginning, so we'll work down the line. Justice Cobbs, you look like you're thinking. That's fine. Take a moment and begin.
That's like the hardest question you've asked all day.
State's attorney's candidates didn't like it either. Go ahead.
No, that's just really, really hard. I really am hard-pressed to come up with the name of a show for my legal program. I only watch Blue Bloods. I don't watch anything else. Okay. So I'm having a hard time coming up with the name of a show.
We'll name it later. What would it look like? What is it? How would it represent Chicago's legal system?
Well, it would look very different from what it looks now. It would look a lot more diverse than it looks now. There would be people from every ethnic background, and there would be certainly a lot more balance in terms of gender on the bench and in our law firms in particular. So we would be more reflective in this show of every type of individual that we serve as judges now. So I guess it could be called All In.
Okay, fair enough. Mr. Epstein.
I think it would be called Generally Accepted but Not Reliable. And it would be about challenging convictions based on bad forensic science. So it would look at instances where we're using bite mark evidence or non-DNA hair follicle analysis, where quacks and charlatans got on our witness stands and were able to qualify as experts because they showed that they used a technique that was generally accepted, which under Illinois Rule of Evidence 702 is all you need to show. Generally accepted, but not reliable. Tarot card readers use techniques that are generally accepted, but they're not reliable, and the consequences are serious. I represented people who were convicted based on this stuff. In bite mark, we know that now, based on research, that those guys are accurate 2% of the time. Non-DNA hair follicle comparison, the FBI reversed course on that. They found out that their experts were testifying inaccurately in 96% of cases. In some of those cases, people were wrongfully convicted, sentenced to death, executed, and then posthumously exonerated. This is stuff that's based in our rules. This is stuff that lingers in the background that we don't necessarily think about but has a massive impact on people's actual rights. Wrongful convictions, we can prevent them. We can change rules. We can make it so that we take rules that exist in almost every other jurisdiction across the country and put them into our own rule set so that our courts can find truth. It would be about those people.
Justice House, what's the name of your show, and what would it look like to depict Chicago's legal system?
I would do a reality show called Cook County Court Watch. I would have the cameras interview witnesses to incidents, either crimes or accidents, and have them take their statements and film those statements, and then contrast it with the trial that takes place later on to compare what information actually gets to the fact finder, either the judge or the jury, and make that comparison and see how that'll educate how our legal system works.
Justice Stanton, Mcbride, the name of your show, and what would it look like?
Mine would be like reality TV, too. It would be an educational program, and it would actually require televising a case. There's civil cases and criminal cases that are going on every single day in our courtrooms. And right now, every circuit in the state has the permission to televise cases. And then when the press wants to actually cover a particular case, they have to get the okay from the circuit judge and the chief judge of that circuit. But I think that it could go a long way to educating people about courts in Illinois, how we function, and it would be educational. And I think that that would be what I would do. I think that it would be so beneficial for people to see how cases are actually tried, and then they can see for themselves whether the system is functioning, how they would react if they were a juror. But I would do something that's close to reality, and I think that it would be educational, and I think that's really what we need. People don't know about judges because, well, they don't see us as much. When we had traffic court in the city of Chicago, people were constantly seeing judges. But I have been in so many courtrooms, I've presided over so many trials, and most of the times the jurors are really grateful that they had the opportunity to serve. So I think we should do something that's reality TV and that will be educational to the public.
Thank you. Justice Reyes, the name of your show, what would it look like?
So is this an hour-long show or I have to?
Sure.
All right, hour-long show. All right. So I would call it the Circle of Justice. And so I would have various members of our legal community sitting around a table, and each month they would be provided with certain problems that we deal on a regular basis with regards to issues. Again, like mental health. You know, how do we deal with the mental health issue right now? In terms of the Cook County Jail, we have a third of the people that are sitting there that are there because they have mental health issues and they haven't been assessed, diagnosed, or treated. And then there would be a follow-up with that program the following week. You know, what solutions have we been able to come up with regards to these? As we mentioned earlier, with regards to some of the rules that need to be implemented and changed and reformed. You know, have people call in and have them actually provide the problems that should be discussed on the program, and then have the experts come up with solutions. I think that would be very beneficial. It might be a little bit on the boring side, but I think it would be exciting in terms of some of the problems that are called in and submitted to the program.
All right, I will submit your programming suggestions to WGN. We'll see what comes out.
Good.
Could be possible. New career for somebody. All right, we'll wrap this up. And first of all, let me start by thanking you all for being here. And for folks who are watching this on television, either on WGN-TV Political Report or on CAN TV, thank you, because hopefully you have found the questions we have asked, while lawyers and judges in the room have found them interesting and very relevant to your work. Our real mission was to have non-lawyers watch and maybe have some fine distinctions to make when you go into that voting booth, and don't just pick a name based on some irrelevant factor, but based on the answers that have been given by these candidates. That's the goal, to inform people, to let them understand, because the judicial system and the justice system impacts all of us, as I'm sure you agree. So, with our thanks for those watching, for those in this room, please help me thank all the candidates who attended today. And I thank you for joining us. Bye-bye.